Okay. Looks like everybody is ready. I'd like to do a really quick sound check. This is the case of State of Iowa versus Michael Buman. State of Iowa is represented by Linda Hines. Would you like to acknowledge you can hear me and let me hear you, Ms. Hines? I can't hear you, Ms. Hines. Bottom left. Gotcha. There you go. Yeah. Perfect. Okay. Thank you. And I'll do the same thing with Ms. Forsyth. I'll make sure you can hear me, and I want to hear you.
I can hear you, Your Honor.
Thank you, and I can hear you as well. I will ask each attorney to please mute your mic when it's not your turn to speak, and we will begin with the state as the applicant for the further review. Linda Hines.
May it please the court, counsel. In October of 2016, the defendant, a registered nurse, wrote on the medical administration record of resident Joseph Lenz that his clorazepine, an antipsychotic medicine that he'd been taking for over 8 years, was to be DC'd. And at trial, it was clear that DC'd meant discontinued. About 8-9 days later, Mr. Lenz had a psychotic break and was hospitalized. And the defendant was then charged with wanton neglect of a resident in a healthcare facility, resulting in serious injury. At trial, the state presented evidence, Exhibit 15, which was a portion of the administrative code setting forth the standards for nurses. And it was just a portion of this code, and we discussed it at trial was only a small portion of that section. And that was the section that guided nurses what to do when a physician prescribed medical regimen cannot be carried out. When this happens, the nurse is obligated to contact the prescribing physician and let him know or her know, and then explain the reasons why, and also to document on the medical record what happened and why. The jury found the defendant guilty of the lesser offense of wanton neglect of a resident of a healthcare facility. And on appeal, the defendant argued first that the district court abused its discretion in admitting Exhibit 15, and next that an instruction 17, which referred to Exhibit 15, together were confusing to the jury. And finally, that there was insufficient evidence of the defendant's guilt. In the dissent, so that's what they argued.
Ms. Hines, can I ask you a question about the administrative regulation issue? I think you said that prescribes the minimum standard of nursing care. Is that correct?
That's my understanding.
And I guess I'm having a little bit of difficulty reading through it and seeing how that pieces out. And as I read it, it's describing what it calls the nurse shall recognize and understand the legal implications of accountability. And then it defines a whole bunch of things about what being accountable means. You know, and it talks about management and supervising people. And does that really directly speak to kind of patient standard of care with respect to the risk with respect to patient care?
I think it informs the jury about what expectation a nurse would have and what reaction they would have if a medication were unavailable. As the defendant testified, the clorazepine was unavailable in this case.
Wouldn't that be an excellent question for an administrative hearing? I'm trying to figure out why was that. It almost seems like it muddied up the waters in a criminal proceeding.
It didn't, because I think the state's theory was twofold. It was that the defendant did not act as the nurses are expected to act through the standards of care, and by not notifying a doctor. But also the other part of that is that the defendant actually wrote DC on the chart. And that's not contained in the administrative rules, but at trial, several witnesses, including the defendant's own, testified that a nurse does not have the authority to discontinue a medicine. So it does inform the defendant's, the knowingness of his actions and that they might likely lead to injury to Mr. Lenz. First, it tells you what's a nurse expected to do in that situation, but then it tells you also, and that's one thing. And then, as I said, the trial testimony describes what a nurse is authorized to do and not.
But doesn't that assume that these regs go to patient health versus some other sort of purpose? So if you look at 625D, sub 2, says the minimum standard of care, at least as you described it, is responsibility for assessing, planning, implementing, and evaluating nursing care. And then there's things about delegation of tasks, but taking accountability for the delegation. And maybe these are standards of administrative liability for the hospital or ways to avoid legal liability, or maybe, I don't know. I guess I don't see the relation between this and risk of injury to patient care, to the patient.
Well, the district court, or sorry, the state focused on only the last section E, in which had to do with medication, and that was what was at issue in this case. And it basically just provides some other reason, some other evidence that this was a normal, in this case, the defendant did not act normally according to standard of care. As a nurse, not even necessarily as a,
Counsel, could you tell us what element of the criminal charge that the state had to prove did Exhibit 15 go to support? How did Exhibit 15 help the jury decide what they needed to decide?
I think it helped them understand that the defendant knowingly acted in a way that would be injurious, because the defendant would have known that when a medication is not there, because he is a nurse, that is when you notify a doctor or make a record in the records, make a note in the record.
Was there proof presented that this particular regulation was known to Mr. Buman?
No, I think that there was evidence that everybody, I think there was the investigator with the director of appeals, I think, who indicated that it was it wasn't known, that standard of care was known. But I think the more important, and this is why, the objection was relevance. I do think it met the standard of relevance, but more importantly, I think, was the state's case that the defendant wrote discontinued. And that was the basis, most of the basis of their argument at trial. So it wasn't a big focus of trial that when they introduced the standards. I think they just wanted to put a baseline on what a nurse would be trained and expected to do when you ran into a situation.
But there was an instruction on it, which would, I think, have made it a focus, right?
Well, the instruction actually is more of a curative instruction. In fact, the court paraphrased that portion E of the 6.52, and then it said that it specifically stated that a violation of this standard in and of itself is not a criminal act, and you can consider the standard only in determining whether state has proven beyond a reasonable doubt that the defendant, the elements of the charge.
I have a question about, go ahead. I thought you were done. Sorry, go ahead.
I'm sorry, you're saying that it was curative, it was helpful to Mr. Buman, but he objected to it, right? The instruction.
I think, because it was helpful to the state and relevant, that's why the exhibit was admitted. The court did not abuse its discretion in admitting that exhibit. Then once it did admit it, the state wrote the instruction to limit the jury's consideration of it and make it very clear.
Wouldn't that be a sweet way to get evidence in? I mean, the state offered 15, correct?
Mm-hmm, yes.
Okay, so the state got that in. And then they offer an instruction that's saying that exhibit that you guys are going to be looking at and reading real carefully in the courtroom or in the jury room, in and of itself, it's not a criminal act. Don't rely on that. doesn't that seem kind of not fair to get it in and then to also provide the cautionary statement that, I mean, obviously the state must have thought it was a big deal because they even specifically said, don't use it for that. I think it doesn't that kind of show that they knew it could be used for that?
I don't think so. I think that the dissent in the Court of Appeals decision, set out that juries are smarter than we think they are. They can understand how to delineate these notions of what makes a person, what is evidence of a person's guilt and what is not. They are not going to be confused when something states it is a standard of care, and they
Yes,
need to find something
Ms.
different.
Hines, can I ask you a question? This is just Justice Oxley. So what is the purpose of introducing instruction number 17? I mean, the curative part of it is to cure the instruction itself. So the bulk of the instruction, why did that need to be as an instruction?
I suspect it was submitted that way because that was the only portion of Exhibit 15 that was relevant. And so rather than, discussing each of the.
Well, but back to Justice Kirshensen's point, we don't generally instruct on what are the relevant exhibits. It's one thing to be allowed to argue in closing that this is a relevant testimony or relevant exhibit, but this is an instruction. So this is a legal matter that you're telling the jury that they need to give special consideration to. And I'm trying to figure out what part. So it ends by saying you may consider the standard only in determining whether the state has proven beyond reasonable doubt the elements of the charge. Which elements?
I think this goes to the defendant as an individual. Not everyone charged with this crime is going to be a registered nurse. And therefore, the defendant's knowledge in committing this offense was important in distinguishing him from an ordinary caregiver. So we have to start with what defendant knew about. And the defendant knew as a nurse, or should have known, that the procedure when a medication is not available is to find somebody, the doctor prescribed it and notify.
Isn't there a risk that the defendant could be convicted for exactly what you're talking about? That is, not following the regulation, as opposed to being convicted of doing what the statute actually requires, which is knowingly acting in a way to harm a resident. I mean, that's the danger when you introduce law and you present it to the jury in a case. That confuses the jury.
I think in this case, the jury, after hearing all the evidence, reading all the instructions, could not have been confused, and could not have thought that simply by not informing a doctor or not marking it on the chart, the defendant knowingly acted in a way. In fact, his witness.
I may ask one more question on that Exhibit 15. Exhibit 15, when we get to the bottom of that, it's talking about it, how they define the word accountability. You have to go way to the top of it. The registered nurse shall recognize and understand the legal implications of accountability. Accountability includes, gosh, I don't mind being held accountable for something, but dang, I don't want that to be used to convict me of something. Isn't that a big leap?
That's another reason why I think the district court submitted the instruction as it did, because he did not put in the legal implications of the actions. It was strictly the action itself. There was nothing about legal.
But you can't look at Exhibit 15 in isolation like that. I don't care what the instruction said. Exhibit 15 was sitting at the jury table. They got to look at it, and it says right there at the very top what they are defining. No matter what that instruction says, Exhibit 15 says they're defining that action is accountability. So I don't think that instruction changes it.
I understand that it could. I don't think that that's kind of assuming a jury can't distinguish between an administrative proceeding, and that might be called legal implications, and a criminal trial where the person is being found guilty by a jury. And the defense attorney also reiterated in his closing argument, that is something you cannot find that the violation of a standard of care equals a criminal act. There's more to it than that, and that was emphasized throughout trial.
Counsel, did the Court of Appeals misunderstand the final sentence of instruction 17? And I'm looking at a sentence on page 9 of their opinion. It says, although the instruction states that the jury may only consider the minimum standard of care in determining whether the state proved the elements of the offense, and then it goes on. When you read that final sentence, you emphasized the word only differently. So they write again, although the instruction states that the jury may only consider the minimum
And the
standard of
instruction
care.
says you may consider this standard only in determining. And I guess it's a slightly different phrasing of it. I think it means the same thing, whether it's.
Does it?
I think it does, yes. I think a person would not say that they could only, particularly after, this doesn't come in isolation. It comes after a whole trial in which these things were discussed, in which closing arguments were made, and the defense attorney pointed out the use of it. And I also would have to say that one of the things the Court of Appeals found is that it wasn't clear which element this applied to. Well, there were 3 elements, and it clearly didn't apply to whether he was a resident or whether it was a healthcare facility. And they determined that he did not cause, that this behavior did not result in serious injury to Mr. Lentz. So it only had to go to the knowingly acted in a way that would be injurious. So that's not confusing, I don't think, about number 17.
You may wrap up.
The state agrees with the dissent. Basically, the juries can handle this kind of information and separate and delineate between these standards, particularly in the context of this trial. The standard would be that it is not very possible. It's not very possible that the jury would confuse or be misled by the instruction and the exhibit. The state requests this court vacate the Court of Appeals decision and affirm the defendant's conviction. Thank you.
Thank you, Ms. Hines. Ms. Forsyth.
Thank you, Your Honor. May it please the court, counsel. The court is questions with the state are exactly what the issue is in this case. We know that Exhibit 14 or Exhibit 15, excuse me, and Instruction 17 were the key to the prosecution's case. It's what the whole case was based on. And how do we know that? We know that through the prosecutor's closing argument. They started volume 3, page 91 to 93. He goes through the elements in State's Exhibit 15 and in the instruction. And he says, this is what the defendant didn't do. This is what he didn't do. And he goes through each one of those. And then he goes straight into the injury. So his whole argument is he didn't follow the administrative code, and that's what he did. There is no argument that he knew. There's no argument that he knew what was in the administrative code, and there was no argument that he knowingly caused this injury or that he knew by making what he thought was a clerical change to the MAR that would cause injury.
Well, but this addresses arguably, I'm sorry.
No, go ahead, Justice Apple.
Thank you. The defense was this was kind of a clerical error. I mean, it was a mistake, if you will. But the rebuttal to that is, whoa, wait a minute. When you put DC in a chart, that's not just some kind of little squiggly squig. And that every registered nurse would know that when you discontinue medication, that is a big deal, all caps. And it requires direct contact with the physician and documentation in the file that the physician, in fact, is discontinued. So it kind of rebuts the notion. I mean, this was a drama. This is on the one side says, well, look, it's a harried and busy staffer who sees the situation and sees that on a couple dates, the 17th, 16th, 17th, the drugs weren't there, and he makes some assumptions. He scribbles something in this chart. He probably should have done it, but that's what happened. And if that's the view of the world, that's not, a crime. The other side of it is, well, wait a minute. Every registered nurse would know that this is a big deal. And when he wrote DC in there, that was a big problem. And so arguably at least, this Exhibit 15 tends to show that nurses should know, and I think you're right. and I need to study the record more. I didn't see anything in the record that suggested that your client was familiar with this Exhibit 15. But I mean, it's the professional standard, and it tends to show that this is a bigger deal than simply a whoops. So I've talked kind of long, and sorry, Justice McDonald. Why don't you respond?
Did you have a question, Justice McDonald, or should I proceed?
No, actually, my question was along similar lines, and I guess I would phrase it this way. Other than non-compliance with this administrative code, what would show this was something other than clerical error? Or maybe that's poorly phrased, but is there evidence that this was anything other than clerical error? Something that would show this was an intentional disregard for the doctor's orders versus trying to correct what your client perceived to be an administrative mistake?
Well, I think what you have to take into account are the protocols of the facility, which this exhibit does not take into account. Nurse Ream testified that when she discovered the clozapine wasn't there, which was before Mr. Buman, she did what the protocols required, and their protocols required the night nurse tells the day nurse, who either contacts the pharmacy or tells the director of nursing, and that person contacts the pharmacy. She testified she did that twice before this happened. You had Mr. Buman who testified that he searched everywhere, that it was actually Mr. Lenz who came up to him and said, why am I not getting this medication? That he searched through, he looked to see if the medication was anywhere, to see if he could find out why. He looked for Mr. Lenz's chart, but his chart was locked in the director of nursing's office. He had no access to it. He did make attempts to try to figure out what was going on. He looked back at the MAR, saw that it had previously not been available.
Counsel, is there evidence in this record, though, that he was kind of changing his story when the investigator started looking into it?
I don't believe there's evidence he was really changing his story. He always said that he had made that record. And a lot of what I'm speaking about right now came from Nurse Ream, because she did the same things. She didn't make that notation on the chart, but she followed the protocols, which was to tell someone else. She didn't contact anybody. She told the nurse the next day whose job it was to contact the pharmacy. So this had been reported at least twice. She was also the nurse who had taken the cassettes when the pharmacy delivers the cassettes to the facility that have all the medications in them. There's a nurse who takes out the old ones and puts in the new ones. She was the person who did that and said the medication was not there. And that was a 2-week supply. Another part of
Justice Waterman here. I'd like to follow up on Justice Apple's question. I mean, isn't the standard of care for a nurse important to the jury's understanding of whether this is a big deal or not to discontinue this medication?
It may be in a sense, but I think the language of the exhibit that went in is what the problem is. Because the language, as was pointed out earlier by the Chief Justice, talks about the legal implications of accountability. The language is basically saying that this document has legal implications. And that's not explained away, even with the cautionary instruction. It doesn't explain that that's not the legal implications and that you can't consider that.
Why doesn't instruction 17 take care of that? I mean, it says clearly that that's not the legal standard and that it can only be used as evidence. Seems right.
I believe the language of the instruction is that that in and of itself, this is not a criminal act. I don't have it right.
Yeah,
I
do.
think,
Yeah, I do have it. A violation
yeah,
of standard is not a criminal act. You may consider the
Justice
standard.
Apple, if you could turn your head when you speak, then we could hear you. Sorry.
Yeah, I know. I have this trouble when I have a notebook here. Sorry.
I need to get you a headphone.
Yeah, a violation of this standard is not a criminal act. You may consider this standard only in determining whether the state has proven beyond a reasonable doubt the elements of the charge. So you got to go back to the elements of the charge, and the professional standards are simply evidence to suggest, as Justice Water said, this is a big deal, not just some bookkeeping problem, arguably.
I understand. I mean, I'm not disagreeing with that. The problem is how it was used. You know, in addition to it, it was used by the prosecutor in a way that goes against what that jury instruction says, because he used it as he did this, he did this, he did this. And that's where I'm referring to volume 3, pages 91 to 93. Also, there's another place where the prosecutor indicates that he couldn't do the second prong, which talked about he couldn't document what he had done or contact the physician because he didn't do that. And that was the law. He refers to the administrative code as the law. So, I mean, he's referring to that as this is the law you follow. But there's no argument about my client's knowledge. And that's what the criminal law, that's what the element of the offense is. And I think that's what causes the confusion, because there is confusion. What do we do with this? This says it's a requirement. What do we do with this? The prosecutor said, this is the law. Well, now we have the judge's instruction from the jury. I think it's confusing. I can see that a jury could very well be confused. And even the defense attorney in his summation, when he tried to clarify it, he misspoke and kind of said, you can't find this as a violation. And if you find it's not a violation, it's not a violation, or words to that effect. So I don't think his language in how he expressed that to the jury clarified anything. If not, it may have confused it more. We do disagree. We do think this was a huge focus of this trial. This and injury, those were the only two things that were the focus of the trial. And based on that, we believe the Court of Appeals was correct, that there's confusion here. I'm not saying writing those initials on the MAR was not a big deal. It was a big deal. But there was also testimony that doesn't go back to the pharmacy. The pharmacy would not have seen that MAR. The pharmacy then would have no reason not to deliver the medication next time. And I understand it goes.
Isn't that a causation argument?
It could be a causation argument, but it also is saying that by writing that on there, he isn't discontinuing the medication. It's still going to come. There's no way the pharmacy was notified. That the pharmacy does not get that document back. So the pharmacy would have no reason to not provide the medication to the facility because he put that notation there. And then if you follow that thought a little bit, if the medication arrives, clearly they're going to look into, has this been discontinued by the doctor or hasn't it? So while, yes, I think it's a big deal that he wrote that on there, it didn't really discontinue it. It didn't really end anything, because the pharmacy still, if they have the order from the doctor, they should be delivering it.
Well, except maybe the next registered nurse or the next caregiver who came in and was supposed to administer drugs looked at the chart and saw DC 2 days earlier and thought, well, okay, and just blew by it. And maybe that person would have been more attentive, but for the DC.
But the testimony was that the drug was not there. It was not delivered. So the next person who came in, it wouldn't have been available to them.
Understand that, but the next person who came in, let's say 2 days later, the drug's not there. There's DC in the chart. When he looks down at the MAR and says, oh, okay, DC, I don't have to worry about the gap. It's DC hadn't been there. And it's instead some other notation or no notation. That caregiver might have said, where is this drug? And might have pursued it.
And my only response is it had been pursued by at least Nurse Ream had done it twice. Mr. Buman looked all over. He testified, I think later, that he did tell the director of nursing. So it already had been brought up. The other thing to note is that the procedures, the MAR comes to the nursing home from the pharmacy, but a new one would have come with the next batch of medication. So
I have
that
a
notation
question.
would,
Follow up on what Justice Apple said. Okay, so if maybe some nurses and some people were already starting to make that, draw that connection, like, where is it? Where is it? So they were starting to get suspicious. Their spidey senses are going off. But once he writes that initial down, as he said, all of a sudden there's not going to be that pursuit. At what point was it discovered? How many times did nurses report it? And at what point was it actually discovered about this notation? Was there days after he put it that nobody started looking into it anymore?
there was no testimony from the director of nursing. There was no testimony from the day nurses. So we don't know if anyone ever followed up on it. We have the testimony that it was reported to them, but we don't know that it was followed up. We don't know what was done because none of that was presented in evidence.
Counsel, is it ever okay to instruct, in a case like this, to instruct on this civil standard of care to guide the jury on what's expected of nurses? Is the problem that Exhibit 15 had some extraneous statements, but would you concede that the jury should be given some guidance of the duty of a nurse in following the doctor's medication instructions?
I don't disagree that they should be given some guidance, but at the same time, they were given no guidance. This seems to trump whatever the protocols were of the facility. And a nurse also has to follow the protocols of their facility. I mean, you can't imagine a situation where every nurse in every place, everywhere, in the state is missing one pill, so they call the doctor. Clearly, that's not going to work. That's not workable. There's protocols. The protocol here was you notify the day person. So what my point is with that is using this as the standard of care, then Nurse Ream also violated it because she didn't do those things either. And the protocols of the facility would mean virtually every nurse that works there would be violating it because that's not the protocol of the place they're working. Their protocol is the director of nursing is the person who makes that phone call and looks into it and represents the facility. And that's where I also think this is misleading because it doesn't take that into account.
You may wrap up.
Thank you. We would ask that you, for these reasons, and find that the jury instruction was confusing, that it most likely could have misled the jury, and that the Court of Appeals opinion be upheld.
Thank you, Ms. Forsyth. Ms. Hines, reply. We can't hear you. Sorry. Do you want to maybe turn your mic on? Thank you.
Sorry about that. I wanted to note that there was competing evidence about whether the medication actually was there. There was a nurse after Nurse Ream that indicated on the MAR that he did give the medication chlorozepine to Mr. Lenz. And then actually the defendant indicated that too in his, on the chart. It's not clear. It sounds like in his testimony, he thought that might've just been his habit. So it's not necessarily so clear cut that this was, the medication wasn't there. But even if it wasn't, that's why the nurse standard of care is important here, because if it wasn't, the standard of care says what should happen from a nurse. And then but what shouldn't ever happen, and this is what I think the bulk of the state's case, is that no nurse would write a discontinued order on a medication, and particularly one. And Mr. Buman, I think, knew this after having worked for the facility as long as he had, particularly one that a person had been on.
All right, Ms. Hines, this is where I struggle a little bit. The state's burden in the case was to prove that Mr. Buman knowingly acted in a manner likely to be injurious to a resident. You had a situation where, I mean, really at most, he didn't have any animosity toward Mr. Lenz. He at most, he made a very poor decision, an error of judgment. So instead of, what strikes me is instead of proving up that he knowingly acted in a manner that's likely to injurious, the state kind of switched the case and had to prove at trial, and instead just proved that Mr. Buman didn't follow a regulation that required him to get a physician approval before discontinuing a medication. And that's a different issue, isn't it?
It is, but that makes the assumption that the jury wasn't able to distinguish the standard of care from the knowingly act in an injurious way to the.
Well, we're kind of sliding between the two issues. I could see how a jury would too.
Well, with all due respect, I think that we presume that juries follow instructions, and that the instructions when read as a whole, and particularly when, again, against the backdrop of the evidence that was presented, the main thing that was emphasized by the doctor was how shocked he was that somebody had written discontinued on this medicine. He was livid. That's how unusual it is. And when you go against the
he wasn't a doctor, he was a physician's assistant, right?
He was a registered nurse.
No. The person you're describing as a doctor was actually a PA.
Yes, I'm sorry. Yes.
And there were, I mean, I read the transcript. There was, one could argue there was some evidence that this particular individual is being made a scapegoat for a combination of circumstances, including a failing by the pharmacy. Isn't that fair? Isn't that a possible inference from the evidence here?
I'm not sure if you can make that inference from the evidence. I guess it's possible. I don't think it's likely. Much like I don't think it's possible. I mean, it's not very possible that the jury could have been misled or confused by the instruction in the exhibit.
Well, if I might ask about that, could I read the final sentence, or would it be reasonable for one to read the final sentence of instruction 17 as you may consider this standard only in determining whether the state has proven beyond a reasonable doubt the elements of the charge? I can only consider that standard.
That could be read that way. I agree. But when this trial, when the judge read the instructions, I assume it didn't read it, that he didn't read it that way, because that's not what he meant. What he meant was.
But how do we know that? I mean, how can I sit here and know that it was read with a certain inflection on that word and the jury heard it in that way and didn't instead go back and read these instructions and look at them in a way that highlights the word only differently?
I think you have to have the faith in the jury that Judge May had, and I have that faith that they understood in reading this that it meant that the only purpose to consider is for determining. It might be capable of being read two ways, but I think in the context of this trial and in the arguments that it would be strange for the jury to read it that way, mostly because Ms. Forsyth mentioned the other nurse. She did report it, the absence of the medicine, and nothing became of it. This is more than not reporting. And I think that the jury is unlikely to have found that simply not reporting was what was the knowingly injurious. It was the simply not reporting plus writing discontinued on the chart. That's what was odd.
So what do we make of the prosecutor's closing argument where he emphasizes just mere non-compliance with the regulation? So he talks about, you've heard about this regulation, it's part of your instruction, and the defendant had to comply. And then he goes on this big rant about cut the fish oil in half, call the doctor. This is not, if you cut the Tums, call the doctor. If you don't put the vitamin B in the applesauce, you got to call the doctor. And he didn't do any of these things. And
well, the evidence
like he's really relying on this technical non-compliance with regulation.
May I finish?
Yeah, please.
The gist of the actual trial testimony was about the discontinued. That was what was special about this case. It made it different. And even though it would have been a violation of the nursing standard not to seek a doctor or write a note in the record, it was more than that. But we needed to start with a baseline for our nurse, because again, this defendant, this didn't have to be, this isn't charged under any code that requires him to be a nurse. The fact is he is a nurse, and that goes to his knowledge of what he has, how he has been trained. And there was testimony that actually even a change such as a Tums or needed to be passed through a doctor. They were very careful about that. That was the testimony how it worked at this facility. Whether the pharmacy also may have made a mistake, that's fine, but nobody but Mr. Buman wrote discontinued, which led everybody else dealt with Mr. Lenz afterward not to administer that medication.
You may wrap up.
Thank you. The state requests this court vacate the Court of Appeals decision and affirm the defendant's conviction. Thank you.
Thank you. And with that, the case of State versus Michael Buman, as well as the earlier case of State versus Dara Swift, both cases are hereby submitted. And I'm going to ask the bailiff to please adjourn court, and we are finished for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa